Hello, everyone. It's Junie checking back in with all of you. I'm just going to try to jump in real quick before the judge starts to speak. This is Stephen Stearns. He is the rapist and the unaliver of Madeline Soto. I got home from work today, and we just got done dinner, and now I'm looking at all this stuff, and I'm just blown away. Where is Jen, the mother of Madeline Soto? Jen Soto does not show up for her daughter today. Please leave me a comment below and tell me how this makes you feel. I'm a little confused. Again, I'm not a lawyer. He pleads no contest, and then he pleads guilty.
William J.
Not really sure how that's going to play out. But okay, let's listen to what he has to say.
Alicia Smith. Beth Borden.
Peter Mills, Alex Johnson.
Ms. Walker might be via online.
State, we have an online presence named Stephanie. Is that representative from the survivor family?
Yes, Your Honor.
Court has admitted an online presence, Stephanie. Also admitting Russ Walker. Court has received two plea forms, one for each of the cases, CF 1293, 2024, CF 632. Court has also received an addendum to the plea form. Ms. Borden, Ms. Smith, do you wish to walk me through the terms of the agreement?
Yes, Judge. In exchange, Mr. Stearns will be entering a plea in the 693 case, the counts 1 through 20. The state will be under counsel in all process 21 through 60. It's going to run concurrently with the 1293 case, and adjudication of guilt as to each life concurrent, and then additionally on the plea.
Thank you. And state as to the addendum. I'm going to ask the folks that have joined us remotely to please mute their microphones. State any special considerations in the addendum to the plea form?
No, Your Honor, we are just incorporating the plea addendum into the plea.
State of Florida filed a notice of intent to seek the penalty of death. That was on June 7th, 2024. Is the state formally going to be withdrawing that notice of intent to seek the penalty of death?
After the acceptance of the plea and pronouncement of sentence, yes.
Thank you. Should that announcement be made by the state of Florida, the proposed sentence will be the maximum sentence allowed by law? Mr. Stern, I'm going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I have two plea forms in my hand. One document looks like this. Second document looks like this. They're each plea forms for your respective cases. They each have a signature. That signature is the same on both plea documents. That signature is next to my finger. Can you tell me if that is your signature?
It's hard to tell from here.
Deputy, will you provide these forms?
Yes, Your Honor.
to the defendant?
Yes, it is.
Thank you. What your signature and a set of initials after each of the 26 paragraphs on each document, those initials being SS, tell me is that you have had an opportunity to read these documents. Do you have any difficulty reading and writing the English language?
I have no difficulty.
And your signature indicates that you are aware of each of the 26 paragraphs and all of the terms and conditions of these two documents. Is that correct?
That is correct.
I have a secondary document. It is an addendum to the plea form. That document is 4 pages long. It appears to have the same initials on the bottom of each of the pages, as well as a signature at the conclusion of the case along with your attorney, Ms. Borden and Ms. Smith. I'm going to ask the deputies to please provide this document to you, and I'm going to ask you to verify that this is your signature.
Yes, Your Honor.
Yes, it is.
What your signature on this document tells me is that you have had an opportunity to read this document, go over it with your attorneys, and you understand the 13 additional conditions of your plea agreement. Is that correct?
That is correct.
Each of the plea form goes over what your trial rights would be. In 2024 CF 1293, you are charged with the allegation of first-degree premeditated murder. In 2024 CF 632, you are charged with 60 counts. The first 9 counts being sexual battery with a child 12 to 18 years of age, counts 10 through 13 being sexual battery with a child 12 to 18 years of age, counts 14 through 20 being lewd or lascivious molestation, counts 21 through 60 being unlawful possession of materials depicting sexual performance by a child, 10 or more images.
Your Honor, counts 1 through 8 are sexual battery on a child under 12.
My apologies. Counts 1 through 8 are capital sexual battery on a child under 12. The plea form contemplates in 2024 CF 1293, 1 count of murder, first degree, capital offense. Plea form on 24 CF 632 contemplates counts 1 through 8, 9 through 13, 14 through 20. With the representation that the state of Florida is withdrawing their notice of intention to seek the penalty of death upon acceptance of this plea, the maximum potential sentence on 24 CF 1293 would be life in prison without possibility of parole. Has the maximum sentence been explained to you?
Yes, Your Honor.
And in 24 CF 632, counts 1 through 8, the maximum potential sentence would be a mandatory sentence of life in prison without possibility of parole. 9 through 13 and 14 through 20 would be first-degree felony allegations with a maximum potential sentence of up to life in prison. You understand those maximum potential sentences on that case?
Yes, Your Honor.
Do you understand that you have a right to have a jury trial as to each of these allegations? And at the jury trial, the state of Florida would have to prove those allegations against you beyond and to the exclusion of every reasonable doubt. At that trial, your attorneys would be with you. They are experienced, board-certified criminal expert trial attorneys. They would be cross-examining witnesses, examining the evidence against you. You would have a right to present your own witnesses and your own evidence. If you had witnesses that did not want to come to court, you could have asked me to make them come to court with a subpoena. You could have spoke at your trial, or you could have exercised your right to remain silent and not spoken. That would have been your decision after you talked those decisions over with your attorneys, and your jury would have been instructed not to consider your decision to remain silent in any way in rendering a verdict. You would have had a right to have your trial recorded and appeal any errors that occurred in the process. Do you understand you are giving up all of your trial rights if the court accepts this plea? Because I will be imposing the sentence that you have agreed with the state of Florida to be imposed upon you, and we will not be having a trial on any of these matters. Do you understand those things?
I understand.
And, Your Honor, just for record purposes, counts 9 through 13 are first-degree felonies punishable by life, as the court indicated. Count 14 through 20 are actually life felonies.
These are life felonies with a minimum mandatory of 25 years. Is life a required sentence, or would that be a punishable by life offense?
It's a life, punishable by life offense. I just wanted the record to be clear. This court indicated first-degree felonies, punishable by life. I just wanted the record to be clear that 14 through 20 are life felonies with 25-year minimum mandatories.
So the plea form indicates that these are first-degree felonies. These are actually either capital offenses or punishable by life offenses. Do you understand that, Mr. Stearns?
Yes, Your Honor.
Is anyone forcing you or pressuring you into make the decision to resolve your case this way?
No, Your Honor.
Has anyone made you any other promises other than what has been presented to you as the agreed-upon sentence?
No, Your Honor.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you are making?
I am not.
Do you understand if you are not a United States citizen, that entry of this plea would subject you to deportation proceedings?
Yes.
And if you ever before had been convicted of a sexually violent or a sexually motivated offense, entry of this plea would have subjected you to involuntary civil commitment at the conclusion of any incarcerative sentence. Do you understand that's the state of Florida law?
Yes.
Ms. Smith, do you have any competency concerns regarding Mr. Stearns' fitness to accept this plea agreement?
No, Judge.
Ms. Borden?
No, Your Honor.
Mr. Stearns, based on your responses to the court, based on your indicating that you have reviewed this decision with your attorneys, based on your initialing of the plea form and your acknowledgement that you understand all the terms and conditions, rights and obligations on these plea forms, including the addendum, the court is going to make a determination that you are alert, that you have had an opportunity to discuss this with your attorneys, that you are making this decision freely and voluntarily and without coercion. court accepts your plea. Let me see the attorneys.
Okay, why he's calling the attorneys up to podium there, I again, I'm just blown away that Jen, the mother of Madeline, who is the real victim here. Madeline is the real victim. And Jen Soto couldn't even show up in court today to give her daughter a voice. Her own daughter. It just, I really hope justice was served today. But it does feel a bit, like justice, something's off here with justice. Okay, let's continue to watch.
has had discussion with the parties regarding the plea of no contest as to 24 CF 1293, the first-degree premeditated murder of Madeline Soto. Mr. Stearns, how do you plea to first-degree premeditated murder in 24 CF 1293?
No contest.
And as to counts 1 through 8, capital sexual battery of Madeline Soto while she was under the age of 12. Counts 9 through 13, sexual battery of Madeline Soto between the ages of 12 and 18. And counts 14 through 20, lewd or lascivious molestation. How do you plead?
Guilty.
Prior to sentencing, does the state care to offer any victim impact testimony?